Martinez. There she is. Okay, we got everybody now. Good. Good morning. Council, your name shows as Gerber on our docket. It shows as Berger on your photo. I'm sure it's Berger, correct?
It is Berger, Your Honor.
Okay, I just want to make sure we get that right for the record. Okay, so are you going to reserve 5 minutes?
Yes, Your Honor, I'd like to reserve 5 minutes.
Okay, we're ready whenever you are.
Thank you, Your Honor. May it please the court, Aaron Berger on behalf of Hattie Wilson. In this case, Ms. Wilson is a homeowner who filed an insurance claim against Citizens Property Insurance Corporation with regard to a water leak in her home that was subsequently denied based on her alleged lack of compliance with post-loss obligations under the policy. We submit to the court that the trial court erred both procedurally and substantively in granting Citizens' motion for summary judgment.
Ms. Berger, can I just ask you a question? Because obviously the big issue here is the EUO, the examination under oath, which was done after 90 days from the complaint, which would be outside of the range within which it should have been done. And there were repeated efforts to schedule it. And your clients made it very clear that she was too ill and under doctor's advice not to go. Okay, is that pretty much accurate so far?
Correct, and I'll fill in some key facts as necessary.
Okay, so I mean, basically the policy says that you know, that the insurance company is entitled to this examination within that 90-day time frame. It did not occur after repeated efforts to do so. I mean, it seems like an open and shut case to me. You know, apparently she was sick. I'm sorry about that. But there were multiple efforts to try to get this done. She was never available to do it. And I mean, the policy says what the policy says, right? I mean, so why isn't she just, you know, have an unfortunate result here and she just loses on this issue?
Your Honor, she doesn't lose on this issue because there is no bright line rule that under Florida law interpreting these types of policies that, you know, the flat out failure to attend is a material breach and there's no further inquiry. As I cited,
it seems like it's a material breach because the examination under oath, when in cases like this, the parts that were repaired were taken away. They didn't have the ability to look at a lot of things on the site because things weren't retained. The examination under oath, I mean, clearly would be material to any one of these claims. It's hard for me to accept that it's not material. I mean, it's the key thing, really, particularly when the evidence hasn't been retained.
Well, I think that the key argument that we've made here, Your Honor, is that materiality is a question of fact, and it's not to be decided on a summary judgment motion. And there's a few things I'd like to point out to the court in terms of the timing here that suggests that this may not have been a material breach and that genuine issues of material fact do remain for the trial court's determination or jury's determination. So when Ms. Wilson notified the insurance company of her claim, they did not, you know, inspect the property for a couple of weeks after that. They didn't send anybody out for a couple of weeks. They waited another month before sending an engineer to inspect the property further. In that time,
this has to do with inspecting the property. The insured, pursuant to the policy in Florida law governing EUOs, has an obligation to sit for an examination under oath about the claim. And the physical inspection and those things are other post-loss obligations, but this is independent. They're not. This is the insured verifying and attesting to the veracity and predicates of the claim. And here's the thing: I've read the law on this. I understand the arguments that have been made to whether there's an issue of fact on her breach, but here's the thing. Citizens requested the EUO 3 times between October and December before the suit was filed and scheduled the EUO. The evidence on this record is barren as far as your client having responded or done anything to communicate her inability to sit for the EUO when citizens asked for it serially. And under Goldman and its progeny, that is a problem for you. It puts your client in the position where she breached that obligation. It's not ambiguous in this policy. So she had the burden then to show that Citizens wasn't prejudiced. Citizens didn't have a burden at that point. They demonstrated the absence of a genuine issue of material fact as to the occurrence of this breach. Having done that, your client was then obligated to come forward with some evidence to excuse or diminish the breach, show substantial compliance or cooperation on the EUO, not with respect to inspecting the premises or the equipment or whatever. So that's where I think the wheels fall off here for this argument. And I would like you to address that issue in the context of Goldman and Estrada, and what Citizens' burden was and what your client's burden was under the applicable law.
Sure, Your Honor. And we've cited numerous cases post-Goldman that suggest that there is a further inquiry to be had into whether or not something or the failure to attend an EUO constitutes a material breach. And my purpose of mentioning what happened before the EUOs was requested is relevant to whether or not her breach was willful, which is part of the inquiry into whether or not there has been a material breach. And that's per the Abdo case that was cited in my briefs, Your Honor. There's numerous cases that suggest that that hold the principle that where there's an explanation provided for the non-compliance.
But where is the explanation for the non-compliance? That's the evidence that's missing.
The explanation is that she was ill during that time.
But where in the record do we see a doctor's note or even an email from her saying, I'm sorry, I can't be there, I'm sick?
I think that's part of the remaining issues of fact, whether or not this was communicated. There's in her deposition that was filed in the record, she said, the question is asked, were you aware that these EUOs were requested? And her response simply was, I know at the time I was ill. And that's what she stated in her affidavit as well. She was ill at the time. She wasn't able to speak to anybody, or she wasn't able to attend. So I think that creates the genuine issue of material fact as to what the insurance company knew and what they did not know. She represented in her affidavit that she told Citizens agent at the time of one of the inspections that she was not feeling well and she could not speak to them at the time. There's nothing to suggest that they didn't know that. And in fact, there's some hearsay in the affidavit of Ms. Dionisio that she refused to comply or she refused to speak to anybody at the time. But I think her affidavit presents a question with regard to what happened in that time. And there is attached to the affidavit that was presented by Citizens is a couple of emails that show that there was an open line of communication between her counsel and Citizens. And in those emails, they represented that they were absolutely willing to have a recorded statement. Now, what's missing from the record also, I think that lends to the argument that there's genuine issue of material fact here as to whether or not Citizens acted diligently in their investigation, were at all prejudiced, is that there's nothing in between the time of that email and more than 3 months later, they're asking for an EUO. And, these conditions are conditions of the policy that she's agreed to. However, they've also been used, as technicalities in this case to create a forfeiture of her coverage, where there's nothing in between the time of the inspection and the filing of the notice of the claim to suggest that they did much of anything else to investigate the claim.
Well, but let's keep the sequence in mind here. Citizens asks for the EUO 3 times between October and December.
Correct.
She's not able to do that, but she is able within a month or two by March of 2017 to file the lawsuit without having sat for the EUO. The EUO is a condition precedent to filing the lawsuit. And to, after the fact, give some deposition testimony, because now she's the plaintiff, she has to show up for a deposition and try to reconstruct that history when she had those 3 months that Citizens was asking, and then she had another couple of months that she could have reached out to Citizens, but didn't, and instead sued them. So that's a problem for you in terms of the framework for summary judgment in EUO cases under Florida law. It's a condition precedent. If there's, if it's been breached, then your client is precluded from recovery unless she can show substantial compliance or a good excuse, evidence of that before the filing of the suit. And we don't have a record of that before the filing of the suit. What we have is her, after she files the lawsuit, explaining that she didn't think it was important enough to comply with that provision before she filed the suit because she had other things to do. But that, I don't think that matches up with the actual law on EUOs, at least as I understand it.
Well, certainly they're not ideal facts for Ms. Wilson, Your Honor. But there is, as cited in my reply brief, authority out of this court that suggests that in determining whether or not, there's been a material breach, the insurer has to demonstrate diligence or before it can be found to be a basis to forfeit coverage, that the insurer must demonstrate diligence in its investigation and that it acted with diligence and in good faith. And the relevance of the other issues and the other timeline facts here go to that argument that they did not demonstrate diligence or in good faith in their investigation. As Judge Morris pointed out, these
isn't the relevant diligence, the diligence in trying to obtain the EUO?
The diligence in obtaining the EUO, again, the record demonstrates that there was an open line of communication via email between counsel and citizens. And then, these were unilateral EUO letters that were issued by Citizens Counsel, which goes to our argument.
What do you mean unilateral letters? I don't understand what you're saying.
There's no evidence that they attempted to coordinate these with counsel for Ms. Wilson. No evidence that they, had any communication other than unilaterally sending these letters saying this is the time and date that you should show up. Now, there's no policy requirement that says that they have to coordinate, but when there's an open line of communication between counsel and
if the line of communication is open, then it would have been easy enough for her to pick up the phone or send an email or her counsel to do it and say, no, not today, next week, she's sick, whatever. But that didn't happen.
Certainly, but I think that lends to the argument that there was no willful breach of the policy here, because there's a question, as in the Abdo case, as to whether or not she knew that these letters were coming in and that she wouldn't have attended if she knew about them. She said she was sick at the time. And I think that creates that there's or lends to our argument that there's genuine issues of material fact here. And I'd just like to point out with regard to again, back to the argument that there was no prejudice here. Again, we have the restoration construction case versus Safe Point that was recently decided by the 4th District Court that sets out a timeline that shows that, even in a case where there was notice of a claim within a few days of the loss, where the insurer did not send anybody to inspect the property within 2 weeks or for 2 weeks, and then did not send an inspector or a professional to inspect the property for another several days. There was a genuine issue of material fact as to whether or not they acted with the requisite diligence to support a finding at a summary judgment that there's no genuine issues of material fact concerning compliance with conditions precedent. Again, the arguments that were made with regard to by citizens with regard to all of these facts, Your Honor, is that there should be no further inquiry after they've demonstrated that Ms. Wilson did not appear for the 3 EUOs. As Judge Morris pointed out, these EUOs were not requested within a reasonable period of time after the notice of claim. There was nothing to suggest in the record that she prevented them from doing any sort of investigation within that 90 days. And that's why those other facts are relevant. The fact that she did participate otherwise in the investigation within those 90 days, because that takes away their argument that she was preventing them from doing something or they could not otherwise make a determination within those 90 days.
It's your position that an investigation is the equivalent of a sworn statement from the insured making the claim?
I'm sorry, Your Honor, can you repeat the question?
So is it your position that allowing an inspection is the equivalent of obtaining the insured's statement under oath regarding the claim?
No, Your Honor, I'm not suggesting that, but what I'm
You keep-
suggesting is
You keep saying they were allowed to inspect. So I don't
Because that's-
understand how that's a substitute for a sworn statement by the insured.
I'm not suggesting it's a substitute. I'm suggesting that she complied with everything they asked her to do within that reasonable period of time,
Except the EUO.
which was requested several months after 4 months after she noticed the claim, months after she demonstrated her willingness through her counsel's email to provide a recorded statement, which they never followed up about or requested. And again, it lends to the suggestion, as we stated in our initial brief, that it's sort of a game here where, at some point they realize they haven't made a determination within a certain period of time, and they have to create a basis to deny by asking for compliance.
Well,
with
if
these
she
policies.
showed up for one of the 3 EUOs, there wouldn't have been a
Hang on,
basis.
everybody, just so we know, we're at
Right.
15 minutes and 25 seconds. So Ms. Berger, you're well into your rebuttal time. So,
Thank you, Your Honor.
yeah, I just want you to know that.
Yeah, I'll just briefly respond and say, correct, according to the record, she did not attend any of those, but at the same time, she did provide an explanation, and the case law that's cited, or the case law that's come out post Goldman, suggests that when you provide an explanation for your non-compliance, there needs to be a further inquiry as to whether or not, her failure to attend prejudiced the insurance company in any way. And I'll reserve the rest of my time, Your Honors.
Okay, you'll have 4 minutes when you come back.
Thank you, Your Honor.
All right, Ms. Martinez?
May it please the court. Good morning. Maureen Martinez with Williams, Leininger and Cosby on behalf of Citizens Property Insurance Corporation. We are requesting that your honors affirm the granting of summary judgment and final judgment in favor of Citizens. I think your honors are very well versed on the issues. The issue is whether or not there was a compliance with the request for the EUO, not compliance with the request for an inspection or to allow the inspection a second time with an engineer, or even the request for a recorded statement, which was.
Ms. Martinez, she was sick, and she was apparently sick for all of them. And we'll never know whether she was really sick or just using this as an excuse unless there is some sort of factual finding about it. So how are we going to know this?
Well, it is correct that in February of 2018, she testified during her deposition that she was sick. However, the explanation for her lack of compliance was not relayed until then. As it's pointed out, the first EUO was scheduled for November 3rd, the second November 17th, and the last December 8th of 2016. So just under 2 years later is when Citizens is advised that the reason she failed to appear was because she was sick. And all the cases that are referred to in the briefs by homeowner, when there is an explanation, that explanation, the reason there's an exception to Goldman where an exception has been found is because the explanation has been relayed prior to filing suit. And that's the critical issue here. Okay, 2 years later, we find out she's sick, but were we told that prior to filing suit? We were able to, Citizens received an email from Mr. Strem's plaintiff's counsel advising that a recorded statement, an in-person recorded statement, would not be allowed. And after that is when the EUO was requested. But I highlight the fact that there was an ability to communicate that an in-person recorded statement wouldn't be permitted, but somehow, some way, there's no ability to communicate that the client is sick or to say, hey, November 3rd doesn't work. We're having a hard time communicating with our client, or we can't communicate with our client. Can we reschedule it? So yes, Your Honor, she has said that she was sick, but that was not relayed prior to filing suit, which is fatal based on the case law. The other issue is that it is well settled that the failure to submit to the EUO is a material breach. That is undisputed. There's no undisputed facts here as to the fact that Citizens requested the EUO the first, the second, and the third time, and that months passed before suit was filed and nothing was done in order to comply. As it was pointed out a few moments ago, the issue is the EUO, not the other things that took part prior to the request to the EUO. So because there were no disputed facts on that issue, summary judgment was appropriate. In response to the motion for summary judgment, plaintiff filed a written response including her affidavit and her deposition. None of the record evidence disputes the fact that the EUOs were requested. None of the record evidence disputes the fact that the plaintiff homeowner failed to appear. None of the record evidence disputes the fact that there was no communication with citizens as to why she failed to appear. The undisputed facts are that plaintiff homeowner did absolutely nothing in response to citizens' multiple requests for EUO. Therefore, there was the material breach. There are other issues presented in the briefs that were not raised at the trial court level, and that includes whether or not there was prejudice or any need, whose burden it was, or whether there was any proof of it. The only issues raised in plaintiff's response at record 434 are whether it was reasonable to request the EUO within the 90 days, and then whether or not there were material issues of fact or disputed issues of fact as to her compliance. The crux of the arguments and issues raised at the trial court were that, quote, I allowed you to inspect my home with the field adjuster. I allowed you to inspect it a second time with the engineer. Therefore, I substantially complied. Therefore, there's a question of fact as to whether or not there was a breach. That's it. There was no issue as to prejudice or whose burden or whatnot. And none of the evidence, even if it had been brought up, plaintiff homeowner did not submit any evidence to rebut the fact that citizens was prejudiced. So it's actually, I think this is a very narrow issue, whether or not there were disputed facts as to the request for the EUO, the failure to comply with the request for EUO, and the fact that it's a material breach based on the law. Therefore, if your honors do not have any further questions for me, I will yield the rest of my time back to the court and ask that your honors affirm the granting of summary judgment and final judgment on behalf of citizens.
Thank you, Ms. Martinez. Ms. Berger, you have 4 minutes.
Thank you, Your Honor. Just briefly, with regard to the argument that the prejudice issue was not preserved, I think it's a bit disingenuous, as it was specifically raised in the motion for summary judgment and record page 413. And the case law that has been cited in our brief suggests that it was an error for the trial court not to even consider it. There was no argument offered in the answer brief that there was any prejudice as a result of her failure to attend. And again, we would just go back to our argument that materiality is a question of fact based on the fact that there's no record evidence that her attendance was not willful, based on the affidavit that she provided that stated that she was unable to attend due to illness. And just briefly as well, with regard to the argument that Ms. Martinez made that the EUOs were requested and there's no suggestion otherwise, that begs the question that was raised with our issue concerning the sufficiency of the affidavit of Ms. Dinesi, of their affidavit in support. I can't say her last name, I apologize. The EUOs were sent by counsel for citizens. There's nothing in the affidavit to suggest that she's competent to testify as to any sort of record keeping.
He's a record custodian. And did you raise this? The issue of the sufficiency of the affidavit was not raised in the trial court.
Your Honor, I'm not sure. I don't think it was raised in the, in the response in opposition. But the record evidence before the court is reviewed de novo, and we would suggest that there's a insufficiency there with regard to the authentication of any of those documents that were sent by their counsel. And again, we would just argue that just request that the final judgment be reversed based on the genuine issues of material fact that remain as to Ms. Wilson's compliance with the post loss obligations.
Thank you both very much. You both did a nice job today, and we very much appreciate it. Have a good day.